Hello friends, as we have seen that on the third day at around 3:30 p.m. Mr. Tilak started his address to the jury as well as to the court. It is important to note that Mr. Tilak started his address on the third day, that is 15th of July 1908 at 3 p.m. After that, Mr. Tilak spoke for the full day on, that is the fourth day, 16th of July 1908. Again on the fifth day, that is 17th of July 1908. On the sixth day, 18th of July 1908. So that is the half of the third day and then entire fourth day, fifth day, sixth day. This entire day, for full day, Mr. Tilak was arguing his case. 19th of July and 20th of July were Saturday and Sunday, so the court was closed. Tilak again spoke for the entire day, that is the seventh day was 21st of July 1908. On the eighth day at around 12:30 p.m. Tilak concluded his submissions. So if you see, Mr. Tilak spoke half day of 15th of July, entire day of 16th, 17th, 18th, 21st. So 4 full days, 1 half day, and 12:30 p.m. on 22nd of July 1908. You will be astonished to know that the total time consumed by Mr. Tilak for his arguments was 21 hours and 10 minutes. So this is the time frame we had argued in his defense. The glimpses are very difficult to be given because as far as this book is concerned, the argument of Mr. Tilak starts at page 92 and concludes at page 192. So there are nearly 100 pages in which Mr. Tilak had spoken on his defense. He spoke on various concepts. He spoke on the interpretation of section 124A. He spoke on the concept of Fox-Libel Act 1792. He gave various case laws. He mentioned various examples of the cases which had taken at that point of time in various other countries. He had spoken the true intention, what has to be proved in a case of sedition. So it's a long process which Mr. Tilak has said. We'll just see some glimpses of this particular speech because 21 hours and 10 minutes, that's a long way. A person is speaking nearly for 4.5 days. That is 4 full days and half day of 15th and half day of 22nd. So you can say a 4.5 day or you can say 5 days this great personality was defending his trial. So we'll just read some basic glimpses to understand. Entire thing is very difficult to be known, but Tilak broke the case of prosecution piece by piece. All the evidence, how they are not proper, how they are not relevant, how they have not proved what has to be proved in a case of sedition, how the exhibits, that is the articles which were produced in the process of prosecution have failed to prove the intention of section 124A, that is, in all, how all the material has not been able to prove the offence is being committed by Mr. Tilak. We will just read some part of it. Mr. Tilak starts, "My lord and gentlemen of jury, the charges are rather vague. I do not know definitely on what portions the prosecution relies. The opening address of the learned counsel for the Crown contained only a few remarks. The net consequence will be that I shall have to cover wider ground and detain you longer than I meant to do." Then he goes on to say what is sedition. A case of sedition divides itself into three parts. First, there is a publication of article. There are certain insinuations, and lastly, the question of intention. Then he says, the publication I have already admitted. I have taken full responsibility of the publication of those articles. Then he says the original has got perverted in the translation. As we have seen that Mr. Joshi was not able to conclude. At the end he said, this is not done by me. This is done by the chief translator. So I should not be held responsible. That was the end of Mr. Joshi's witness and cross-examination. Then he says, they say you have to judge from the writing themselves whether they are seditious or not. I think the matter is not so simple as that. The question of intention is the main question in this case. See, that is what is important. Whether the intention was proved by prosecution. There where the whole thing revolves. A witness who says, I have not done translation. Second witness says, I am a distributor. Third witness says, I have just executed the warrants which itself are into problem. So none of the witness proves the intention behind the articles in a way. They are very technical witnesses. Then he says, I want to point out the article is written in Marathi and addressed to Marathi knowing population. Then he says to the jury, you have to judge what effect this article is likely to produce. That is, what is the tendency of the words employed and what effect they would probably produce on the minds of the Marathi speaking population. The Kesari is only read by Marathi speaking people. And then a very important submission. It is not read all over India. It's a very important aspect to be kept in mind because you are trying under a central law the case of sedition, and this particular paper is not at all read all over India. So you have not to say what effect would be in Bengal. No, he is very clear in that aspect. Then he goes on to say, no other fact or piece of evidence has been placed before you except the articles themselves. So ultimately, he comes to a particular thing and explains the jury that except the articles, nothing has been put before you. The witness says translation done by chief translator, distributor is mere distributor, police officer is mere a person executing warrant. So none of them prove any intention behind the article which the article would have on the Marathi speaking people. He also says at one place that I have already explained that the word perversity, duragraha, is mistranslated. It should be stubbornness. So in this entire 21 hours and 10 minutes of his defense, Mr. Tilak clearly put forth before the jury as to how the offense is not being made out. He had already given 3 limbs of an offense: publication, insinuations and intention, of which he said, I accept publication. But whether the rest of the 2 and more the intention and the effect it would have, whether it was proved, none of the witness could prove. Obviously, the documents which were put forth before the prosecution, again none of the document proved the intention, the main aspect as to what effect this particular article would have on the Marathi speaking people who read this article. This aspect was totally missing. Neither it was proved by any witness nor by documentation. Friends, it's a long 100 pages arguments by Mr. Tilak. So I have not covered everything, but I would request all of you to get this book and read by yourself the excellent command Mr. Tilak had on the law, the manner in which he broke the case piece by piece. He clearly showed the jury that prosecution has failed to prove the offense against Mr. Tilak. With this background, Mr. Tilak concluded his argument on 22nd of July 1908 at around 12:30 p.m. and he thanked all the jury for the patience they have shown. We'll stop in this particular episode here. In our next episode, we will see the dramatic incidences, yes, dramatic incidences which had taken place on 22nd of July 1908. Thank you.